number 32 and 33, Gottwald v. Sebert. Counsel.
Thank you, Your Honor. Anton Metlitsky for Kesha Rose Sebert. I'd like to reserve 3 minutes if I could.
You have 3 minutes.
Thank you, and may it please the Court. Kesha has for nearly a decade had to defend against what we will show to be a baseless lawsuit brought to retaliate against her for her speech. That suit has required Kesha to spend millions of dollars in her own defense. It has required her to endure, among many other things, being deposed about the details of her sex life. And in July, she'll have to be cross-examined about her rape in a very public Manhattan courtroom.
Counselor, do you think there's a difference between the constitutional actual malice standard and the anti-SLAPP one?
No, I don't think so. So the legislature enacted the November 2020 anti-SLAPP amendments in large part to provide a remedy to victims of such vindictive lawsuits and also to ensure that the actual malice standard applies in all cases.
Did they indicate that it was retroactive at the time?
I think they indicated it was retroactive in several different ways. So the first is just the stated purpose of the act. The stated purpose of the act was the 2020 legislature understood that the 92 Act was supposed to provide maximum protection for First Amendment rights.
But Counsel, you're not suggesting, and I don't see it in the papers, that that 92 Act was meant to do what the later amendments did.
No, what's relevant is the intent of the 2020 legislature, and the 2020 legislature understood that the original act was...
But I think that's relevant for the amendments, certainly.
Yeah.
But why is that relevant for the 1992 statute?
It's not. The 1992 statute is totally irrelevant, except insofar as the 1992 statute had a particular purpose, a stated purpose, which was utmost protection for free speech. And the 2020 legislature, that's what's relevant, thought, we understood that purpose, we agree with that purpose, and we think it was supposed to protect a group of people and interests that it in fact did not protect. It fell short.
That's the question, though. Supposed to protect, or we now want to protect more?
Well, I think probably both. And the legislative history makes clear.
And so does that fork there, if we want to call it that, the both you just said, does one branch of that or the other affect whether you think of this as remedial?
No, I don't think so. So what I understand, I mean, remedial can mean a lot of things, as the cases have said. The way I understand it as relevant to this analysis is when a legislature understands that prior law was supposed to, should have, protected a particular interest or group of people and didn't, the new legislature...
The should have, though, is ambiguous. Right?
So I don't mean should have in the sense that it actually did, but then like turned out not to. I mean, the statute was supposed to provide maximum protection for free speech.
Well, it was maximum protection to a particular class, and now the idea is the class really, we look at it now, we think we would like to provide it to a bigger class.
That's
fair?
right. And because the prior statute was should have, in the sense not that it was written to, but what the intent was not to have these kinds of retaliatory lawsuits. And just, I think it's easier to speak in particulars. So the impetus for the statute was the legislature, this is in the legislative history, noticing that there was a proliferation of vindictive, harassing, retaliatory lawsuits against journalists, consumer advocates, and survivors of sexual abuse. And the legislature said, we need an amendment so that these people are protected. And it seems to me bizarre to presume that the legislature would not want to provide a remedy for the very people that were the impetus for the statute in the first place. But I think this is just one argument. I mean, move on to the actual statutory amendment history, right? The statute had a prospective-only provision in it, and it was removed. This court has held both within the retroactivity context in Majewski, and outside of that context, that is extremely pertinent evidence of the legislature's intent, because of course it is. Imagine a legislator that wants the statute to apply prospectively, and that legislator sees the bill, and it has a prospective-only provision. Why on earth
Wouldn't it have just been easier for the legislation to so state it is retroactive?
Well, so I think lots of legislation says that, lots of legislation says prospective only. This doctrine has developed to account for legislation that says neither, right? So express retroactivity is not required, but there are a few reasons.
But there was nothing to stop them from simply stating it at the time that they passed.
So I think that there might be a few explanations for why somebody wouldn't have expressly stated retroactively. Imagine somebody wanted the statute to apply retroactively in the sense that it applied to pending cases, but not retroactively in the sense that it applied to completed cases. Putting in a retroactivity provision could have created ambiguity
You
there.
said that in your retroactivity provision? This applies to pending cases only?
You could have, Your Honor, but another reason why you wouldn't have said that is because there's commenced or continued language in the statute already, which seems to me to imply
I was thinking about
application to
that.
pending cases.
Commence and continued. Exactly. Would you agree with the proposition that by using the phrase commenced or continued, continued would suggest that they meant application to already pending cases?
Yeah, I think that's totally obvious.
Is that
That's
a
what
rec-
it means.
I'm sorry, just quickly, by corollary to that, they could have said, they could have included language that indicated that with respect to those cases that had already been commenced, that it was effective back to the commencement, but that's not what you get.
Well, let me be clear. I was going to say at the beginning, we have a fallback argument here, which is that we at the very least should get damages from the date of commencement on. That's not even a retroactive application. That's just a present day application, and I can't imagine why we wouldn't be entitled to that. But as to the retroactivity piece, again, it's true that the legislature obviously could have said this statute applies retroactively. It could have been more clear. That's true in every single one of these
What's
cases.
your retroactivity, what's the retroactive application here then? Because as Judge Canataro was saying, it seems like application to a current case, especially given the language of the statute, it's not retroactive. So what's the retroactive application?
So
you're
I'm not going to fight you on that. I think that's right. I mean, so applying the actual malice standard to a case that hasn't continued at the end of the case doesn't even seem
What
like
about
it.
punitive and compensatory damages?
Well, so that one, there could be a retroactive application as to attorney's fees, punitive and compensatory damages, depending on when you start. Right.
Attorney's fees seems fairly simple if you use the pivot as the statute passes, and from then on you can mark attorney's fees. But how about compensatory and punitive?
So same thing, compensatory damages. If you wanted a purely non-retroactive application, you would do compensatories from the effective date and whatever punitive damages were available based on conduct after the effective date. Because after all, the signal from the legislature is if you are currently prosecuting a baseless vindictive lawsuit, stop. And if you don't stop, why wouldn't the victim of that lawsuit be entitled to all the entire panoply of remedies?
Is there a way to consistently read 76A and 70A, taking into account the continued and maintained language, so that the, I don't want to call it retroactivity, but application to pending cases applies in 70A but not in 76A? That is to say, they
So
deal
in
with different
theory-
things.
In theory, like two different provisions could be different in terms of retroactivity. I think in this case, there are some reasons to not think that. So the commenced or continued language, I think, is not just relevant to whether, you're entitled to damages from the date of the effective date, but just generally implies the existence of an already existing lawsuit. That's one. And there's, on 76A, there's language that says that the actual malice standard applies when you're seeking to recover damages, and the Becker case is very similar. It suggests not full retroactivity, that is, to completed proceedings, but the intent to apply that sort of standard at the end of the case if the case hasn't ended yet.
But you might say that the standard is, in 76A, doesn't apply to a pending case, but the provisions of 70A allowing for counterclaims and damages and...
You could, in theory, say that, but another reason not to say that, Your Honor, is because there was a prospective-only provision in the statute that applied to both provisions. And then one thing that I haven't mentioned that this Court has also held to be quite important in determining the meaning of the statute is the public commentary on this. There was commentary in the bill jacket that said, by the way, the commenced or continued language plus the deletion of the prospective-only provision is going to make courts read this as retroactive. So, and that's bad, they said. And so the
That was a letter
governor,
from
you shouldn't sign
somebody,
it.
right? Was that a letter from somebody?
There were a lot of letters, and, that was a letter.
That was one letter, though, from, who was that from? I can't.
It was from the Rent Stabilization Association, which is an important association when it comes to these kinds of suits because they all often happen in landlord-tenant disputes. But this court in Duel against Condon didn't suggest that you had to have a lot of letters. The point is that the bill jacket is the material that is before the governor. And when there is express understanding by interested parties that a statute is going to be applied retroactively, that is good evidence that the statute was intended to be retroactive. And the thing that I don't understand is the answer to the deletion.
Any issue do you see a due process issue with the punitive damages being applied to commencement prior to the effective date of the statute?
Your Honor, I don't think that there is any punitive damages issue here for the very simple reason that you never have a right to file a frivolous litigation. Remember, if this litigation is found not to be frivolous, none of this applies. It only applies to frivolous litigation. And there is no vested right, due process interest, or anything else in filing lawsuits. The punitive damages provision only applies to lawsuits commenced or continued for the sole purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the exercise of free speech. What due process right could possibly protect that kind of lawsuit?
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court, Christine LaPera on behalf of respondents. I would like to first, if I might...
Could you just pick up on that point? Why do you have a right to file a frivolous
Yes, Your Honor, let me say
retaliatory
at this
lawsuit?
outset, this is not a frivolous litigation. We didn't file a frivolous litigation. We filed a defamation action in response to Ms. Sebert starting the litigation, and we take great issue with that. But getting right, if I might, to these issues that the Court has flagged as considerable relevance to these issues, obviously there is a presumption against retroactivity, which can be overcome, but it is not eliminated.
I wonder why you think of this as retroactive to begin with. That is, suppose for a moment that instead of 76A, the legislature said, we're going to cap defamation damages at $1 million. And for a case that hadn't gone to trial yet, wouldn't you think that that cap would apply? And if not, what's the vested property interest in the unlimited damages as opposed to the cap?
Here, I think that it is retroactive for two reasons, as the Regina Court did say,
Well,
and as Lansgrove said, with respect to substantive
Can you try
rights.
my question about a damages cap
Yes.
first, and then say whatever you
So
like
the
to say?
remedy issue, with respect to a potential remedy on an existing claim, may very well be considered remedial and procedural. This is a situation where you have a substantive change in the fault element of an existing claim, and you also have a situation where you have increased liability, not just attorney's fees aside, but compensatory and punitive damages that are attendant to that new retroactive decision.
The difficulty I have with that, I think, is that you could reduce that cap from my $1 million example to $1, and you would still characterize that as procedural, where here you've toughened the standard for liability, but that might have less of an actual effect.
I think it has potentially more of an effect, Your Honor. I think that obviously it's a case-by-case analysis, but when you impose on someone who's litigated for 6, now almost 9 years, a new claim for potential compensatory and punitive damages, as Landgraf says, clearly punitive damages is something that is abhorred in terms of a constitutional sense for retroactivity. I do believe that this is a retroactive application. 76A adds a new element of fault to an existing cause of action. It changes that, and it adds new claims for liability on compensatory and damages. I would love to
You
address the
pled
continued.
malice, though, right?
We did, but ultimately, and here's where there's this issue, we are now, of course, the court reverses, we are a private figure with a burden of proof of negligence. We have litigated that case for 6 years in reliance on existing law. That is clearly one of the factors that the courts consider when looking at both the due process, but also the impairment of rights. So I believe that we have a retroactive application being sought affecting substantive rights under Regina. You look at that, and then you look to the clear intent. There's no clear intent here. There's no express intent. The continue language is from the 1992 statute, which is not retroactive. It was simply adopted over, and as the court here said in Shieldcrawl, maintaining, which is the same thing as continuing, can have two different meanings. It can have the meaning, as appellant urges, of continuing with respect to a pending case, but it can also have the meaning of continuing a new case that's filed upon which there's a determination that to continue it would be potentially frivolous. Would be, for example, if I was accusing someone of defaming me and I sued so-and-so, and then in discovery I learned, well, it literally wasn't so-and-so, it was someone else. That is the
Wouldn't
situation.
that interpretation make the word that comes before it, commenced, superfluous in this context?
No, Your Honor, in Shieldcroft, there was institute or maintain. It was the exact same analysis. So commence,
Maintain in legalese has kind of a another meaning, right?
It's ambiguous. Here's the point, Your Honor. With all due respect from our position, they're grasping at various things. Let me talk about the deletion, which is one of the centerpieces of their argument. If you look back at the bill that was changed, there was also a significant number of procedural changes that were made with respect to 3211. Procedural changes with respect to a stay, procedural changes with respect to affidavits being submitted on a motion to dismiss. So it could clearly have been spelled out. We intend this to apply to pending cases, as was said in Regina. Even in Regina, the court wasn't clear that pending cases meant pending cases, but I think we would say if it says pending cases, it means pending cases. It didn't alter that. It didn't change that. It added some procedural changes. It wasn't a singular change between the two drafts, which is significant. So you have the issue of the continue, which I think is ambiguity at best. You have the issue of the deletion, which is ambiguity at best. You have a remedial concept, which is, there's lots of different definitions for remedial. I don't think that, as Majewski says, passes the muster to get it over the presumption. And you really only have the other word immediately, which this court has repeatedly says
But
does
now,
not
now you've got a little bit of a
survive.
cumulative, now you've got a bit of a cumulative
Yeah,
effect.
I thought
right?
of
So,
that, Your Honor,
Yes,
and-
this
yes.
alone is not good enough. This
Correct.
is insufficient standing on its own.
Yes.
This also will not get you past the line, but at some point,
Well, I
all
think
of
that,
those have to have some meaning and impact on
I've
on
thought
your
about that a lot,
analysis.
Your Honor, and here's
Good
where I
thing.
think. Ambiguity plus ambiguity plus ambiguity plus ambiguity is 0 plus 0 equals 0. It's like a contract. If the more ambiguities you have, doesn't make it more clearer or susceptible. And here's the point. It's the legislature's burden. They know the law. They know what they're supposed to do to make it clearer for application. This is, I've not seen a single case, and we've
Well,
scoured the...
but he is correct about this, that really the debate is about what happens when you don't use the word prospectively or retroactively, right?
Right, that's right. There's no clear
The point is,
intent.
there is jurisprudence. If it had been expressed, we wouldn't be here. The whole point
Correct.
is what happens when it is not
That's right.
expressed.
That's right.
But I do think that neither side has fully responded to some of the questioning, certainly from Judge Wilson, but I think from other members of the bench, why this is really a case about retroactivity.
Because it impairs significant rights,
Yes,
substantive
and
rights.
what would those rights be?
The
In
rights
this-
would
In
be-
this case, what
In
what
this
are those
case, the
rights?
right would be, assuming there's affirmance of the private figure status, that it would be a change in the fault element of a cause of action. A cause of action is a substantive right. It would be a change in the burden of proof on that fault
But you
element.
have no decision yet on
No, I understand
malice
that.
yet.
Yes.
You pled malice.
Yes.
You've argued and litigated malice.
Yes.
You're up here on malice, so how are we changing the standard for a verdict that hasn't happened yet?
Well, if these are going to be decided presumably together, there is an interplay, and one is not moot by the other because...
But isn't that the point in part that I think my colleague is asking about, and he'll correct me if I'm wrong, that if you start the litigation uncertain what burden may be imposed,
Right.
then what possible substantive right is being adversely affected by a decision that is not the one you were looking for?
If this court were to determine that he is still a private figure, then there is a substantive impact. Also, clearly, it's the new liability.
But all I'm saying, but that's the point, right?
So that's the
You
right
went
that's
into the
impacted.
litigation not knowing where that would go. You had
Yes,
your
I understand.
arguments. You
Yes.
certainly thought they were colorable, if not the ones that
Correct.
would be persuasive. But
And
the fact of
also-
the matter is, the court may very well hold against you, moving up the food chain, right?
May very well. But again, now you're confronted with the issue with respect to both the new claim for liability for compensatory and punitive. And there's no question that applying that in this context, even on a going forward basis, it would be theoretically like saying to a court or a jury, well, let's forget about the 9 years of litigation. Let's only look at the trial and see whether there is a substantial basis for the trial. It's I don't want to say slicing the salami too thin, but it's a dichotomy that's a fiction. So of course you can't just apply it prospectively.
But there's something
In a case-
there's
and-
something that's unusual about your substantive due process claim, which is that ordinarily the substantive right that's claimed is something on which the person relied in taking some action. And this is different. That is, the substantive claim that you're making is a claim that you have a right to the essentially legal rules for determining a dispute the way that they existed previously. And I can't think of another case like that.
I think that with respect to the issue of whether or not there's a SLAPP statute on the books, every practitioner and every client looks to see whether there's a SLAPP statute or not in pursuing a claim early on, because it does change the burden, it does change the whole metrics, and you're relying on existing laws as to the whole point of a SLAPP statute, and very different in the other states. California doesn't have anything this broad. You are taking steps, you are pursuing your litigation strategy in the absence of an anti-SLAPP statute, of course.
But don't you prepare for the possibility that he's not deemed to be a private person?
Yes, but that doesn't bring on the claims of liability then. It doesn't bring on the compensatory or punitive damages claims. That is one single, but these are to be, I guess, the
So the
court.
actual malice part is one part, but you're
Correct.
talking about the exposure.
70A, Your Honor.
The exposure.
Yes, 76A is the new definition and the broad swath that has been given now to this anti-SLAPP statute in New York, far more broadly than, I would say, most anti-SLAPP statutes around the country.
It just seems to me a fairly dangerous proposition to claim that you have a substantive due process right in the rules of evidence, in the rules of the burden of proof, in how much damages you can occur, in all the things that go into getting a claim you have litigated to its end, that claiming a substantive due process right in those things would really impair the legislature and the courts in their ability to adapt the law.
This is beyond a rule of evidence, Your Honor, and I think that appellant has cited a couple of cases about changing a rule of evidence might not be an impairment, but the court has also given a lot of clarity in saying that a question of vested rights or substantive rights is a case-by-case analysis. It has to be looked at in the concept of fairness. It has to be looked at in the context of how long of a retroactivity, even before you get to due process, which of course, if you look at 6 to 9 years of a retroactivity application, I've not seen any case that has sanctioned anything that lengthy.
So does your entire argument then turn on whether or not we agree with you that there's a substantive right that's impaired? If we disagree with you on that, do you lose?
If you disagree that there's a substantive right that is affected by virtue of 76A and 70A, then I think we're still in the land of, is there an express legislative intent? I think that's the balance. I do not agree that it's moot, but I think that obviously, to the extent we are correct, and we believe we are, that by virtue of this 76A, which is changing a fault element of a statute, of a cause of action, and the 70A liability component combined, those two under this court's jurisprudence and in the analysis of the span of retroactivity being afforded generally, even though that's usually looked at in due process cases, it should be looked at just generally. If you look at it in that context, I think what you're seeing is here, you must have a clear expression. And there was ample opportunity to do it. I think the cherry picking that's going on here to close that gap of the express legislative intent is where I think the burden shifts back to rebut the presumption against retroactivity. It is not rebutted unless there is that clear expression or by necessary implication required.
Counsel, I see
Yes.
your time is up, but one last
Yes,
thing.
Your Honor.
If we were to find that there is an application of the anti-SLAPP statute's malice standard, is there any reason for us to decide the public-private figure issue?
Yes, Your Honor, there is. It is not moot, and that is because there are a number of statements that arguably fall within the private category. That would be her burden of proving that effectively some of the statements that were made in a private context, not a public forum. Yes, it's not moot.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Just a few points. So first of all, as to due process, the Supreme Court held, I think for the first time in 1912, that there is no due process right to a particular burden of proof or anything like that. We cite the cases in our reply brief there, Easterling, Lumber, and Reitler. As to a due process right as to the counterclaim, what this court explained in Regina is that there's a due process issue when your past conduct was immunized by then current law. You never had the right to file frivolous litigation. You never had the right to file harassing litigation. There was exposure for sanctions, disbarment, malicious prosecution, all of that. All the legislature did was make the sanctions stronger. As to this point about layering ambiguity upon ambiguity, that's not what we're talking about. Every single one of the things that we have cited is evidence in favor of retroactive intent. And so we think any one of them really is sufficient, but when you layer them all on top of each other, I mean, the fact that the legislature took out a prospective-only provision, the fact that commenters understood the effect, the commence or continued language, all of that is evidence in our favor, and cumulatively, it's got to be sufficient. As to the Shieldcraft case, that case did not use the words commence, it used maintain. Maintain in law can mean starting a lawsuit or it can mean continuing a lawsuit. Continuing cannot mean starting a lawsuit, and it obviously can't mean starting a lawsuit when the phrase is commence or continued, right? And then finally, the deletion of the prospective-only provision. I have not heard an explanation for that deletion other than that they didn't want it to apply prospective-only. A legislator looking at that bill, seeing a prospective-only provision and saying, you know what, I want this bill to be prospective-only, so I am going to delete the prospective-only provision is nonsense. That can't possibly have happened. The only reason why you would have deleted it is because you didn't want it to apply. That's what the court held in Majewski, and that's what the court held in the grand jury cases. And we think that is, even by itself, and certainly with all the other evidence, dispositive of the legislature's retroactive intent.
Thank you. Counsel, would you like to move on to privileges and public figure?
One second to flip everything around here.
I'm sorry, Anton.
Oh, yeah, no problem. So, thank you again, Your Honor. I'd like to reserve 3 minutes on this one also. So here there are two independent issues, as the court knows, and I'd like to start with the litigation privilege issue because it's got a lot of moving pieces, and then hopefully I'll have a little bit of time at the end to talk about public figure. So there are three different related litigation privileges here: the absolute privilege for statements made in court, the Section 74 privilege for statements made about litigation, and the pre-litigation privilege. So as to the absolute litigation privilege first, the First Department has recognized the Sham exception for that privilege, and the First Department's decision is just definitionally incorrect. The whole point of the absolute privilege for statements made in litigation is that it affords no exceptions. It is, so long as the statements are pertinent to the litigation, which is not in dispute, there is no malice exception to that
Did you
privilege.
make that argument, or was your argument that this wasn't a sham litigation?
Right, so our argument was that it wasn't a sham litigation. We still have that fallback argument as to the absolute privilege point. This waiver piece, by the way, only applies to the absolute privilege. It doesn't apply to the other one. And so that is not a waiver for two reasons. The first reason is that this court can always hear purely legal questions, I'm just quoting, if it could not have been obviated or cured by factual showings or legal countersteps in the court of first instance, and that obviously applies here. But the actual reason why we didn't raise it is because the First Department recognized the sham exception, like in the 80s, the 1980s, I believe. It didn't come up for a while, and there were a bunch of federal district courts and New York trial courts that had said, this is a weird decision, it's an outlier decision, it's inconsistent with Court of Appeals precedent. And one of those decisions, one of those trial court decisions, was the Flomenhaft decision. That's what the trial court held. That one went up to the First Department, and all of these arguments that we're making here were vetted in that case. That was the argument, that the original sham exception was just definitionally inconsistent with this court's precedent.
But
And the
it
First
hadn't
Department...
been decided here, whether the Flomenhoff decision was valid or not. Isn't that an argument you could have made at the trial court?
No, I don't think so. I mean, the trial court was bound by the Flomenhoff decision, and the appellate division was certainly not, it would have been totally futile to re-argue that point when they had rejected these very same arguments 3 years earlier, right? Why would we have ever done that? And it seems to me the only court that can decide that the First Department's sham exception is invalid is this court. We raised this argument in the motion for leave to appeal, and the appellate division granted the motion. So,
And you were not willing to risk that a different panel might see it your way?
I don't
It
think
does happen in the First Department, it happens sometimes in the division, where different
No, I
panels
don't.
come out different ways,
I don't
no?
think the appellate
No?
division would have had authority to overrule its own 3-year-old prior decision, especially when these particular arguments were vetted. But if the court has a worry about that, again, I
Well,
would
no,
just...
I said that because you say these arguments came up in that, in the other case.
Woman half, yeah.
Not that they had been decided in the 80s when the doctrine is originally adopted.
Right,
Strikes
exactly.
me as more recent and might very well have lent itself to an argument of why the prior panel perhaps went astray.
No, sorry, let me just start again. So
Yes.
in 2015, these arguments were raised, not in 1980, whatever. In
Right.
2015, these
Yes.
arguments were raised, and the appellate division just rejected them. It said that its own sham exception decision was not an outlier. And so 3 years later, we're supposed to say it was?
Why is that holding wrong, substantively?
So that holding was wrong because since, I think, 1890, this court has said that as a definitional matter, the absolute litigation privilege does not have any kind of malice exception. I think their argument, if I understand it, is that might be true for statements made in an already existing litigation, but it doesn't apply to a litigation that started for some bad purpose. And that argument is just foreclosed by the court's decision in Wiener against Weintraub, which was the defamatory statements were in the commencement, the complaint filed in that litigation, and it also seems to me to make no sense. And if anything, right, the purposes behind the absolute litigation privilege apply with more force when you're commencing a litigation, because there's a petition clause right to commence litigation, and the very last thing you would want is for someone with a meritorious claim to think twice about bringing that claim because they're worried about a defamation suit brought against them. And then on the other side of the ledger, unlike just for statements made within litigation, the commencement of a frivolous litigation, as we've already discussed, is already subject to sanction, disbarment, whatever, malicious prosecution, all of that. So there's just no reason to create this strange, totally unheard of exception to the absolute litigation privilege. So that's 5 of the statements that were made in like complaints, counterclaims, and the like. Then there are 19 statements under Section 74. This is the fair report privilege. And the main argument there is that the court's decision in Williams against Williams applies, and so the privilege doesn't apply. That is a sham exception. Williams against Williams is something akin to a sham exception. The question is its scope. And it seems to me that Williams doesn't apply here for 2 reasons. So Williams the worry there was somebody files a complaint purely for purposes to defame. That complaint is privileged, by the way. The whole premise of Williams is that the complaint is privileged. But then you send out a press release to publish it, and then you're going to hide behind Section 74. Williams said, that's no good. But here, my client, on the same day that she filed a complaint, became the defendant in this case. You can't possibly apply the Williams exception to the defendant in a litigation talking about her defenses. That is nobody's ever even thought to argue that.
Another unusual thing about Williams, if I remember the facts correctly, which is it was a breakup of the partnership between 2 brothers, and the one brother was using the lawsuit, and particularly the dissemination of the press release, to send to the trade group, essentially to injure the business of his brother who he
That's
had.
right.
So there was like an anti-competitive element to it.
Yeah,
as
that's
well.
right. I mean, it was a very strange case, and it's kind of a strange decision because, of course, the statute not only doesn't admit of any exceptions, but had been amended in the past to get rid of a malice exception. Like, there was a malice exception in the statute, and then that was taken out. And so if you...
So would it apply to the California action that your client brought and
No.
not the New York action?
No, so our primary submission, well, there's no difference between the two, right? They
One's
were
a
brought on the same
counterclaim, I
day.
thought you said.
Say it again?
One's a counterclaim. I thought you said that Williams doesn't apply to counterclaims.
No, Williams doesn't apply when you're a defendant in a lawsuit. So what happened here is my client filed a lawsuit, same day they filed a lawsuit.
And are
this
some of
lawsuit.
the statements included in that lawsuit? Allegedly defamatory, are some of the allegedly defamatory statements included in the California lawsuit your client filed?
So what I'm talking about, none of these statements were in the lawsuit. They were about lawsuits. They were like, here are our allegations. Right?
So were they
Yeah.
about the California suit or no?
They're the same. The California
But
suit...
California's an affirmative suit, and I thought you were making a distinction about counterclaims under
Not
Williams.
counterclaims. So we are a defendant in this action. Every single one of these statements was made as a defendant in this action. This action is, you defamed me when you made the allegation that Dr. Luke drugged and raped my client. And all these statements were, no, those statements, those are true.
Is that a little bit cutting it a little thin? Because you bring an action, and then you use this as a defense here, and you're commenting also on that action, and you're knocking out that as an absolute litigation privilege, but then you're saying there's no Williams exception because you're only commenting as a defense.
Well, I mean, this is what happened, right? So they file a complaint, they have this
But you
press
filed
blitz.
a
We filed a complaint, they filed a complaint, we both filed a complaint. There was a press blitz on their side, they're going to say there was one on our side, fine, for present purposes, let's just assume. But they tried to absolutely destroy my client's reputation in the press.
That's kind of what this
and-
case is all about.
Absolutely,
But two cases get filed.
Yeah.
You file, they file.
Right.
And now you say, no, this is only, applies to our defense. But you filed.
But it's
right?
not that it only applies to our defense. I'm just saying the statute is absolute. There is a tiny exception to the statute that you have to construe narrowly. I mean, courts don't even do this anymore, right? But you have to construe the exception narrowly because it's not in the statute. And all I'm saying is, in this circumstance, when you're both a plaintiff and a defendant, and the statements are relevant to both your suit and the other suit, Williams can't apply. But also, in any event, just forget about the defense for a second. Williams can't apply anyway, because the only way that Williams makes sense in combination with the deletion of the actual malice provision from this statute is you can't interpret Williams as just like a malice provision.
So the California suit
Yeah.
that was discontinued is irrelevant.
No, right now I'm arguing that just assume that it is relevant. Assume that the only suit was the California suit for present purposes. I think we win on the fact that they sued us and we were a defendant, but if you don't like that, here's another argument.
Even though your client is the first one that instituted an action.
Yeah, because this isn't about statements in the action. This is about public statements and whether they're privileged under the fair report privilege. Your parties are always allowed to talk about their own litigation or whether they're a defendant or a plaintiff.
And this would apply, though, to the copy of your complaint that you sent to TMZ before the litigation started.
So I think that one applies both under the fair report privilege and the
Let's stick to
pre-litigation
this
privilege.
one. You're arguing
The fair
that
report.
fair reporting would apply because you're raising this defense in New York to you sending your complaint in the California action to the TMZ.
No, so that's the one statement that wouldn't apply as a defendant because we weren't a defendant then. But it would apply. Let me explain why the Williams exception shouldn't apply, even if you forget about the fact that we're defendants. I
So
think
that's just anticipation of litigation, the TMZ.
no, that's also under the fair report privilege. The reason that sort of embargoed copies of complaints should fall under the fair report privilege is because the whole purpose of that privilege is to make sure that the public understands fair and accurate and quick reporting of judicial proceedings.
At least as to that statement, there's no argument that that's made as part of your defense to the New York.
Yeah, that's right. So let me try to be totally clear. I have two arguments for why Williams doesn't apply. One of them is that one, so I think we're right about that, but for present purposes, assume I just never said it. And now we're just talking about our complaint, okay? So there's a second reason why the Williams exception doesn't apply, because I think the Williams exception has to apply only to complaints that are not real complaints. They're filed purely for purposes of defamation and not as an instrument to institute.
Issue here?
Say it
Why
again?
isn't that a jury question?
Because you know that, just as a matter of fact, that this litigation was prosecuted. My client filed the California litigation. It was stayed in favor of this action. She tried to get the stay lifted.
So that's the rule? If you pursue the action?
Yes, I think so. So
How far do you have to go with that pursuit?
Well, I think if you start litigating, it's probably enough, but let me just tell you what my client did.
Start litigating as in, I filed the lawsuit?
No. If you actually start engaging in the litigation process, because then,
Filing motions, responding to motions?
Yeah, and here's what happened here. So she filed the complaint. It was stayed in favor of this action. She tried to get the stay lifted. She appeared at multiple conferences. When it became clear that she wasn't going to get the stay lifted, she dropped that action and filed the exact same action here as counterclaims, right? She litigated that through a motion to dismiss. That was dismissed on limitations grounds. She appealed, dropped the appeal, and instead tried to...
So wherever the line might be drawn, you
Yeah.
don't necessarily have to draw that today.
No,
or at
because-
least in this case, because this is so far past any
Exactly. You
possible
don't
line.
Exactly. You don't have to draw the line here because this is, she litigated these claims either in California or in New York.
So
all
is
the
your
way
rule that
through.
if all you do is file and do nothing else?
Yeah, I
Or
think...
eventually withdraw, abandon?
Yes, because, and ironically enough, I think a good model for this kind of exception that I'm talking about is how the New York courts the appellate division, the first department, before this case, understood its own sham exception to the absolute privilege. Every one of those cases was always about litigation that actually was not pursued. And the reason they thought that that was okay as a sham exception is because it wasn't
What
real
if you've made
litigation.
an error? What if you made an error in your assessment about your lawsuit, and you file, you get an answer, a motion to dismiss, and you're persuaded, and now you withdraw?
Well, so I think that would be an additional kind of situation where
I'm saying, could they pursue this argument that it's a sham, and that would then be a fact question? This
That
is
might be
why
a
we
fact
abandoned
question
it.
unless there are no facts, material facts in dispute, but that could be a fact question. It can't be a fact question when the litigation was actually pursued. And again, if you construe the Williams exception more broadly than that, you're just going to have a malice exception, which is what the legislature excised from the statute in the first place.
Thank you, counsel.
Okay. I'm happy to answer on public figure on rebuttal if you have
Use
any
your rebuttal
questions.
for that.
Okay.
Yes. Please.
Good afternoon, Your Honors. David Steinberg for respondents. May it please the court. We have a very unique situation here, Your Honor. This is the rare situation where the improper purpose and the sole and improper purpose of the litigant's activity is spelled out in writing. Her press plan stated that it was designed to incite a deluge of negative media attention and public pressure.
But what's an absolute privilege if there's a sham exception?
Your Honor, I think this court has enunciated, going back over a century, that if a privilege is abused, then protection is withdrawn. And I think that the sham exception as
Then
articulated...
there's
That
never an
reads
absolute.
absolute, yeah, I'm sorry, that takes absolute out of the equation. What does absolute mean, if not that?
Well, I think in this situation, Your Honor, as the First Department has articulated for 40 years now, when something is filed for a sole and improper purpose, that it doesn't come within any kind of
The
privilege.
difficulty I'm having with the line you were about to go down, which is the deluge of negative publicity, scorched earth, burn these people to the ground, destroy their families and all that sort of stuff, is that doesn't mean that the allegations aren't true, right? You might actually have a meritorious claim and still be super aggressive and want to destroy your adversary. So I'm not sure why that line you were going to go down matters.
Especially in this industry, since this is a common practice.
Because, Your Honor, in this particular situation and these unique facts, the evidence supports a conclusion that the sole reason the litigation was filed was to defame the respondent in order to try to achieve something that was
But
otherwise
doesn't the
unavailable.
Doesn't the balancing of the qualified and absolute privileges get you that? An absolute privilege applies to the documents you filed, and these qualified privileges take into account the argument you're making.
Well, Your Honor, of course, we do believe that the qualified privileges for the press statements and the pre-litigation statements certainly do protect those statements, but for the purpose of someone who just files a complaint and does nothing else, but that complaint is for a sole and improper purpose, what is the remedy for that person?
So you reject the argument that this was not a situation where it was just a filing of a complaint and nothing else? I mean, there was stay litigation in California, there was a number of motions made right through a dismissal motion in New York, so this is not, the test that's being promoted here is, let's see how serious they were about this litigation. And it seems as if they were.
Your Honor, we take very much an opposition to any argument that this was litigated. This case was filed, it was abandoned. She said she would amend, she didn't. She said she would appeal, she didn't. There was no litigation on the merits, and the issue of whether or not she intended to litigate is an issue that should go to the jury. I think it's important to emphasize that none of...
Well, the intent issue carries weight at the point you're deciding whether or not to file, correct?
I'm sorry.
The moment she's deciding to file, that's about the intent. I'm filing this, I thought your argument was, the only point of filing this is because I wish to defame, because I'm trying to get them to, I'm trying to coerce them to give me what I've demanded in these negotiations. I thought that was your argument.
Correct, Your Honor.
Okay, so she files, and then your client files, right?
Yes.
So is it possible that one would then say we've got to have a particular strategy, given now that we're not only in a plaintiff position in this jurisdiction, but we're in a defendant's position in this other jurisdiction?
Your Honor,
Would that not call for counsel to reconsider strategy and
If
sit
you're-
down
if-
with their client?
If Your Honor is referring to the exception to, in Williams, for the litigation, for the statements made to the press, there is no such exception enunciated in Williams. Williams simply says that if you file a malicious action and then you try to get publicity for that malicious action, you can lose whatever privilege exists, and you could be subject to a defamation claim. And in Williams, it was just a motion to dismiss. There were just allegations.
Let me ask you this. I understood you to be arguing that the plan that you discover is the smoking gun. What if there's no plan, but there are press statements?
Your Honor,
Is it then a fact question that goes to the jury whether or not those statements to the press were intended as part of this plan of solely filing to defame, coerce?
Your Honor, each case would obviously have to be looked at on its own individual merits. We have that plan here, and we certainly have a reasonable basis for a jury to conclude that this was filed for sole and improper purpose. And it's important to
I'm
emphasize...
just trying to get a better sense of sort of the contours of this rule. If you don't have the plan, I understand in your case you think we've got, as they say, the goods. But let's say you don't have the plan. What else might reveal this? Is it merely you filed and did nothing else but made these statements to the press or made public statements?
No, Your Honor, I think you're going to be put to the test, and you're going to be put to the test early on as to whether you can actually show that there was a sole and improper purpose for the filing of the litigation. It's important to emphasize, Your Honor, that...
Not have a chilling effect that undermines the purpose of the exception.
I'm sorry?
How does that not have a chilling effect that undermines the purpose?
A chilling effect for filing a lawsuit?
Well, yes, and perhaps particular types of very candid conversations between lawyer and client,
Are you talking about...
public statements.
The pre-litigation privilege now?
Yes.
Your Honor, the pre-litigation privilege as enunciated in the seminal case that was decided by this court front referred to communications between counsel that was leading up to litigation. And in that case, what they said was, in essence, you can't have blackmail, you can't have extortion, you can't have defamation in pre-litigation communications. Those privileges are not protected. And what the court said was, you have to have good faith anticipated litigation. Now, good faith anticipated litigation can't just mean I have a defamatory, blackmail, extortion purpose, but I have a good faith belief that I'm going to file a meritless lawsuit, so therefore I'm protected. It has to be good faith litigation. And that, we do not have that here. There's ample evidence. The court, the trial court, and the First Department unanimously found issues of fact to go to the jury as to whether these privileges should apply. They did not reject these privileges. She still can assert those privileges.
Counsel, is there a difference? You're using language sole improper purpose filing. Is there a difference between that and malice?
Yes, Your Honor, I believe it is. When you're using the litigation for an ulterior purpose, for a purpose that has nothing to do with the actual merits of the litigation, then that should be considered different than malice. You are, in essence, abusing the court process. You are using it as a tool of oppression itself.
Isn't that a little, I'm not sure about that. I mean, I think I've had clients who filed, let's say, breach of contract actions and securities fraud actions, where what they really wanted was a patent license. And they were using a piece of litigation as a leverage to get something else they wanted. I didn't see anything wrong with that.
Well, Your Honor, I think you'd have to look at the facts of that particular case, but here we have, in writing, spelled out.
But it is for exactly the way you described it, an ulterior purpose having nothing really to do with the breach of contract litigation. Now, those were not frivolous breach of contract litigations, but I'm not sure that the ulterior purpose gets you where you want to go.
Well, I think that the ulterior purpose that we're talking about here is the purpose to defame, the purpose to destroy someone's reputation.
Though, I mean, I think you're avoiding malice because I think Andrews v. Gardner, our case, says you can't destroy an absolute privilege by showing malice, right? So you're kind of stuck on malice. So I'm trying to understand what the difference is between your standard and malice.
Well, Your Honor, I think that the sham litigation exception as expressed in the First Department has articulated that. I see that I'm running out of time. If I could just address the one issue that I think is important here on the waiver issue, and the waiver issue is this court, the trial court and the First Department all looked at this with the assumption that the sham litigation exception applied. And therefore, what it did was it didn't look through each defamatory publication and didn't assess each litigation privilege for each defamatory publication. And because that happened, because they found issues of fact with regard to the sham litigation, there was no separate adjudication or separate looking at every one of those facts. As a result, even if this court finds that there is no sham litigation exception, there certainly are issues of fact as to whether under Williams or whether under Front, those privileges should apply to any statement that was not made in the litigation. And if this court is inclined to find that there's no sham litigation, at the very least, it needs to remand this to the court to go through each and every separate defamatory statement to determine whether any litigation privilege applies in any way.
And let me just ask you real quickly, if this court were to hold that Mr. Gottwald is indeed a general purpose public figure or even a limited purpose public figure, how would that affect the arguments with respect to the qualified privileges?
I think, Your Honor, either way, we have to have a jury determine whether the privilege applies, whether he's a general purpose figure or a limited purpose public figure. But I'd like to address those if the court is inclined.
About 10 seconds of it.
Your Honor, there's no evidence that he was a household name. Who knew of him beforehand? Your Honor, everything that the cases say, all the cases relied upon say that even for limited purpose public figure, there has to be some direct relationship between the person who thrust himself into the vortex of the public discussion, even if it's not a public
And how do you
debate.
define the public in that? Unfortunately, apparently, there are many Americans who don't know the 9 members of the U.S. Supreme Court.
Your Honor,
And I think we all think they're public. Yes?
well,
Or do you disagree? Maybe you
No,
don't think
Your
so.
Honor, I know all 9 members. Don't test me, but I do know all 9 members. But
As long as you know the 6 here, you're in good shape.
Thank you, Your Honor. But in terms of the limited purpose public figure test, there has to be some relationship between the person who thrusts himself into the public, a public figure, and the defamation. And here, Mr. Gottwald was a songwriter, was a producer, and then we go back to 2014 for the analysis. He was putting himself out as a songwriter, as a music
I know, but who
producer.
would thrust themselves into the conversation of being, of talking about sexual assault and young artists? It seems to me that even if it was true or not true, that wouldn't be a subject that he would be entertaining. So shouldn't we expand that a little more?
No, Your Honor, and here's why. Because if that would apply to everybody who puts themselves into the public, if I'm the manager of a Target and I do a commercial, a local commercial, and I talk about the people who come in, the customers who come in, the vendors who I work with, my employees, come on in, this is a great place.
So
Does that make me a...
Roman Polanski a limited public figure?
I don't know the facts of whether Mr. Polanski would be considered a limited public figure. For what purpose, Your Honor?
Well, for the purpose of an action presumably where the 13-year-old that he had sex with,
Yeah,
filed a complaint like this.
Perhaps,
right?
but under the facts here,
Well,
Your
but
Honor...
why? But he's a director just like Mr. Gottwald.
Well, I assume the court doesn't think that every director is a public figure, every songwriter is a public figure. You have to look at each particular set of facts.
So
Just by...
so is the question here really not whether he has injected himself into the vortex of public discussion about sexual assault, but rather within the world of songwriting or music production or something like that, in that world he's a limited public figure?
Your Honor, if he was being accused of being a plagiarist or copyright infringement, then yes, he would be a limited purpose public figure. But the person at Target who talks about his employees, his vendors,
And
his
it
customers...
doesn't matter that associating with these young women was a part of that?
Your Honor, they were the singers. Not only young women, but young men and older people were singers of his songs.
Mr. Gottwald certainly spent a fair amount of time pre-litigation talking about his successful collaboration with Kesha specifically, didn't he?
Your Honor, he certainly did hold himself out as a songwriter, as a music producer, and publicized his success as such, and the people-
Collaborating with this defendant.
collaborating with lots of artists, Your Honor, that's correct. But that doesn't make him a limited purpose public figure for the purpose of all potential defamations, whether in the Target example, whether it's going to be someone who's accusing him falsely, the manager of fraud, or being a racist.
Yeah, but isn't that different? I mean, is it really fair to compare him to someone at Target? This is someone, the Supreme Court said, look, if you have access to the media and you could address these comments, then it's more likely that you're a public figure. So someone like Dr. Luke could call up, seemingly, Rolling Stone or Billboard and say, I want to do an interview. And you know what? They'd show up. But a manager at Target would say that and wouldn't get very far.
Well, I'm not sure there's a distinction there under the limited purpose public figure test, Your Honor. If you're not putting yourself out there that in the category of the issues that are at issue in the defamation, then you're not a limited purpose public
What about a
figure.
general, just a general figure?
If you're, in order to be a general purpose public figure, you have to be, in essence, a household name.
Well, in this industry, he was in essence a household name.
Your Honor, but the defamation didn't occur in the industry. Appellant defamed my client throughout the world. She defamed him by going on social media with her millions of followers. She defamed him by going to TMZ and to the LA Times and to Nightline on television.
He can seek out interviews and be in the public, but as long as his publicity is solely related to music, he's not a public figure.
Well, Your Honor, I don't think that's necessarily so. If you are so pervasive in the public, if you are so well known throughout the public, then you are indeed a general purpose public figure. But those are the rare creatures that are as enunciated by the Supreme Court.
Yes, but not everyone has to be. As I said, not everyone knows those 9 members. So it doesn't have to be that it's only that half of the 1%. Right?
Well,
the class can be larger than that. I think
yes,
that's the point. So then how much farther do you have to go to include people in? What do they have to do? And I'm a little bit confused by your argument because although, yes, I get your point that he's sort of in this niche and that's where perhaps he's known, the reality is the niche is directly connected to the clients. It is directly about how he manages his clients, how he can bring them fame, how he helps them actually achieve their artistry. And I thought she was alleging, yes, but all of that comes with physical, emotional abuse. And that's what she is pursuing. Whether or not she can make her claims is another story, but those are her allegations.
Your Honor, with regards to the publicity about his expertise, about his profession,
Yes.
again, it's about him being a songwriter and a music producer. To the extent others, journalists, actually go in and they talk about his relationship with artists or about anything more than him being a music producer or a songwriter, that doesn't mean that he has thrust himself into that area of discussion. It has to be him voluntarily doing that. And there's no evidence in the record that shows
But
that
his notoriety is because of that success, is it not?
you can, and again, success, of course, Your Honor,
I
is,
might have written a song 5 minutes ago. No one's going to care about it, right?
but Your Honor, of course, success in your profession is not sufficient to make you
That is true.
a
That
general
is
purpose
true.
public figure. And he was successful, of course he was successful, and like any good businessman, he promoted his business. And,
Well, he solicited great public interest in him.
I'm sorry?
He solicited tremendous public interest in him,
In him, in
not merely his clients.
his business, in his songwriting, that's correct. And that doesn't make him.
In the world of artistry like this, you
Yes.
are the business.
Yes, but
It
that
is
doesn't
him.
make him a public figure.
Well, do you think New York has a different definition of public figure than the Supreme Court does?
I think that New York's definition of public figure should be consistent with Gertz as enunciated by the Supreme Court.
Does it have to be?
It doesn't have to be, but I think it can be and it should be. And I think that in this particular situation, the evidence is just not there that his fame prior to 2014 was so pervasive that everybody knew who he was. Who knew who, and we talked about things like American Idol and the Walk of Fame. I mean, who knew who Simon Cowell was before he was on American Idol? I mean, there's just a certain amount of
Some people in England kind of knew him. Some people in England kind of knew him, which is just circling back to my point. It depends what you think is the public and who knows who. I may know people that you would never know.
I
In
think
my
that-
community, they may be extremely well known.
I think your point is a good one, and I think it has to be defined by who is she defaming him in front of. And that's the world here. She didn't just pick some record companies to defame him. She went on social media to her millions of followers. She went to TMZ, Nightline, television interviews. That's what she did to defame him, to ruin him for these false allegations. Last point is that the burden is on the appellant to show that he's a public figure, and it has to be done by clear and convincing evidence. We submit that the First Department was correct.
Thank you, counsel.
Thank you, Your Honors.
So, Mr. Militsky, could Dr. Luke be a general purpose public figure? Did you show that, or at least make sufficient allegations of that?
For sure.
How so?
So, I mean, 1 week after this litigation was filed, his counsel filed a sworn affidavit in a trial court calling him a celebrity. He was a celebrity. He hired 4 public relations firms to make himself famous, not just as a music producer, but as a music producer for young female artists. He was chosen to get a Hollywood star in the Hollywood Walk of Fame. That's for famous people. He was a finalist as a judge in American Idol. Those producers don't pick people who aren't going to draw an audience. He was the subject of, articles in the New Yorker, Billboard, New York Magazine. He was invited to red carpets. I mean,
There was just an argument made that for purposes of determining whether or not someone is a public figure, especially a general purpose public figure, you have to look at the audience to which the claims and statements are being made. And, in this context, Dr. Luke, I would venture to guess maybe more people in the back of the room know who Dr. Luke is than in the front of the room.
absolutely, and that
So
is...
is that a valid way of doing it?
Well, first of all, that is wrong. There's no case that says that, and it can't possibly be right, because in the world of social media, everything gets retweeted to everybody immediately. But as to whether more young people would know Dr. Luke than any of us, it seems to me that that's an argument in our favor, because it can't possibly be, the test can't be whether the judges or the lawyers talk about this person in their household. It's whether, I'll just read from James. The essential element underlying the category of public figures is that the publicized person has taken an affirmative step to attract public attention. And, in James, that was a limited purpose public figure. She was a belly dancer in Rochester, and she attracted public attention as a belly dancer. So articles about her belly dancing counted. It's
But the defamation, the defamatory statements, as I understand it in that case, came out of her interview, right?
Well, that's true, but not in Park, for example. Park was an eye doctor, and he had publicized his business, and he was accused of being unethical in his medical practice. He had never written an article about medical ethics. He just sort of got notoriety in this little community, and so allegations within the scope of the notoriety that he sought out made him a limited public figure. That test is easily satisfied here. I mean, it's hard. It's pretty hard for me, I think, to better Justice Scarpulla's formulation. She said he's a limited purpose public figure because he's purposefully and continuously publicized and promoted his business relationship with his young female music artists like Kesha to continue to attract publicity for himself and new talent for his label. The allegedly defamatory statements at issue directly relate to Dr. Luke's self-publicized professional and personal relationships with his clients, his integrity in business practices, and in attracting new talent. That's exactly right. And if a guy at a Target...
But the claim here is not that your client was attempting to destroy Dr. Luke's reputation in the music industry. It was that it was directed towards the entire world, that this was going to be very newsworthy, and people were going to revile Dr. Luke.
Your Honor, there has never been a case that, as far as I know, that looks at how widely disseminated the defamation was. I've never heard of such a case, and it would make no sense today, because any statement by a famous person is going to be disseminated to everybody immediately. Okay,
Well, you're just saying, if you say it to one person, it's defamatory. If you say it to a million, it's defamatory. That's not the point.
Exactly. That's not the point.
Let's say you're a famous eye surgeon and you go and you speak and you publish papers about eye surgery and you're an eye surgeon for, young people.
Yep.
Now, someone comes in and says, I was abused, sexually abused, I was one of this doctor's patients. You're a limited purpose public figure?
For purposes of those statements, that's right. And here, I think the connection is even closer, because he touted how good of a music producer he was with
Eye
respect.
doctor touts how good of an eye surgeon he is.
Then yes, he
for,
would be
yeah,
a limited purpose public
people
figure.
accusing him of molesting his patient.
He would be a limited purpose public figure for that purpose, but Dr. Luke is not just a limited purpose public figure. Limited purpose public figures don't get chosen for stars on the Walk of Fame.
So what are you arguing? Which one is your better argument, do you think? General public or limited?
I mean, limited seems to me obvious, but I don't even understand the contrary argument. But
And do you think that New York has a different standard than the Supreme Court?
I don't think so, but I mean, this court should follow its own precedent, right? And so if that's a precedent construing the New York Constitution, the court's never made that clear, but the precedent is the precedent. If the court has, I'd like to just answer a few of the points on the litigation privilege. So one point is that all of this can be worked out in front of the jury. That just eviscerates, these are privileges. These are privileges against litigation. That eviscerates the purpose of the privilege, so they have to be construed very narrowly.
But aren't they credibility assessments? So just send it to the jury to make their credibility findings?
But that's an argument in my favor, because there are always going to be credibility findings, and they're always going to go to the jury. You can always concoct some argument that this was made up to pressure Dr. Luke to let her out of the contract or whatever, and that means they wouldn't be privileges. The whole point of the privilege is that you can decide it at the outset of the case, and the person doesn't have to be subject to the litigation.
What's the difference then between an absolute and a qualified?
So I wanted to answer your question about that. So as a general matter, absolute privileges have no exceptions. Qualified privileges have a malice exception, but not the front qualified privilege. In front, the court expressly held that it was not adopting a general malice standard. So the court said, rather than applying a general malice standard to this pre-litigation stage, the privilege should only be applied to statements pertinent to a good faith anticipated litigation. And I think we've cited the California courts that have a very similar pre-litigation standard that explicate what that means. So the dispute is about whether that means that the litigation that you actually anticipated was going to be filed with malice, which would be a malice exception, or whether you actually anticipated in good faith filing a real litigation. The California courts hold the latter.
I don't read Front's language exactly that way. I mean, it says they have to be pertinent to a good faith anticipated litigation.
That's
right? So I don't think that's just filing in good faith. I think it has to be, I think that's a sham exception.
Well, so
a good faith anticipated
It's a
litigation.
sham exception to a certain extent, but it can't be a malice exception because Front said it's not adopting a malice exception. So here's the California standard. I think it's basically identical. It's a pre-litigation communication is privileged only when it relates to litigation that is contemplated in good faith and under serious consideration. And the California Supreme Court in the Action Apartment case, which we discuss at length, explained what that means. It does not mean a malice exception, that is, that the litigation that you anticipated to file was going to be filed for the purposes of defamation.
Aren't they alleging, even under the California test, that you fail?
Yeah, they're alleging it, but they can't just allege it, right? We know the facts. We know the facts.
Been through a number of discovery, et cetera. Like, why isn't this a jury issue?
This is not, so my colleague said that this privilege applies when you file a complaint and do nothing else. And fine, that's fine with us. But there is no plausible dispute of fact that my client did nothing else.
What if that isn't the test? What if the test is a good faith case that we said in our Front decision? Isn't they're saying that's not? They've brought forth certain evidence. You've countered that.
Well,
why are we going to decide that?
It depends on what you mean by a good faith case. If by a good faith case you mean a malice exception, that is, you didn't believe the allegations or you had a reckless regard for their truth, then yeah, that would be a fact dispute. Our argument is it can't be a malice exception because Front said so. And second of all, it wouldn't protect the privilege, the privilege that the court was trying to protect, which is statements in anticipation of a litigation that was likely to be filed or anticipated to be filed. That's what the California Supreme Court explained. And if you disagree with the California Supreme Court, then only as to these pre-litigation statements, I can't make an argument that there's not a fact question.
And does the content of those pre-litigation statements matter in any way? And here I'm specifically thinking of the Lady Gaga text message.
So that one's not subject to.
It's not part of it.
It's not part of this. The content of the statements does matter to this extent. I'm quoting from Front. They have to be pertinent to the anticipated litigation. I just want to make one other point, if I could, because this is about the waiver issue. So the waiver issue, their waiver argument can only possibly be even applicable to the absolute privilege. We did not argue that there was no exception to the report privilege. We argued that the exception didn't apply. They say the court never considered the particular statements that would fall under that privilege to see whether they actually did. There's a reason the court never did that. They never asked the trial court to do so. They didn't even mention it in the appellate division. And you can't raise a fact question for the first time in this court. And not only that, they are judicially stopped from making that argument. They sought leave. The original complaint that they filed in this case was only about statements made before Kesha filed her complaint. Then they sought to amend. And we said, you can't do that, the limitations period has expired. They said they relate back, and the reason they relate back is that all the statements that we're talking about right now are simply reiterations of the general allegation that Dr. Luke drugged and raped Kesha. They won. That is what the trial court said. That's why the trial court let them amend their complaint. We appealed. The appellate division affirmed. And now they're saying that maybe these statements are actually broader than the general allegations. That is the entire purpose for the judicial estoppel doctrine. You can't win, and then once you've won, change your mind about what the facts are. Thank you, Your Honor.